On February 11, 2026, in a Michigan family court, judge presided over a show cause hearing in case 24-19620-DS involving defendant Timothy Bennett. Bennett faces potential contempt charges for failing to pay any child support since a uniform support order took effect in March 2024, with arrears now totaling $16,103 against a monthly obligation of $703. The hearing was complicated by Bennett's presence at an inpatient drug rehabilitation facility in Flint, where he has been since October 2025, raising critical questions about how courts balance enforcement of support obligations against a parent's genuine incapacity to earn income.
Ms. Kraus, can you update me as to this matter?
Yes, this hearing has been adjourned 4 times from the referee to address contempt, as the defendant has failed to pay anything since the uniform support order entered. He's not made a diligent effort to pay anything at all of the amount that's due, and the defendant does not have a physical disability that prevents him from working. The defendant's support obligation is $703. The overdue support balance is $16,103.
When did the uniform child support order enter?
It entered on August 8th of 24 with an effective date of March of 2024.
That's not fair.
Hold on, I'm trying to mute.
And the friend of the court indicates that there's been no payments at all since at least August of 24.
Correct.
What do you have to say for yourself?
I'm in rehab right now, as time being. My plan is to get out and go to work after this, after I get out of rehab, but I'm in rehab right now. I did start a new program that's going to hire me a lawyer, so I am addressed, but I am in rehab right now.
When did you enter rehab?
October 28th, maybe 4 months ago.
Where are you physically located?
Flint, Michigan.
What's the nature of your rehab there?
What do you mean nature of it?
Well, is it an inpatient program? Are
Yeah,
you
yeah.
free to leave?
No,
Since October? Since
Yeah.
October? You're not able to leave campus? What's the name of the facility that you're at? Who's the gentleman that's with you there today?
my counselor.
Your Honor, I'm Tim's counselor. He's currently at Flint Odyssey House, has been since October. We're a long-term inpatient residential treatment center for drug addiction. We did just sign him up for a program that we have called Impact, which is going to help either pay some of his child support, or get him like legal representation on the matter. As of right now, there's no anticipated discharge date because our program can over a year sometimes. And he's unable to leave the campus at this moment and get a job and work, but he did express to me that he plans on addressing this matter moving forward.
Ms. Schultz, do you have any additional information that you'd like me to be aware of?
The prosecutor established that Bennett has made 0 child support payments despite an order effective March 2024, while Bennett and his counselor explained he has been in locked inpatient drug rehabilitation since October 2025 with no ability to work or leave the facility. Under Michigan compiled laws, Section 552.603, 2, child support obligations accrue as a judgment by operation of law and cannot be unilaterally suspended by a parent's circumstances, though courts retain equitable authority to modify orders prospectively under Section 552.517 when a parent's ability to pay changes substantially. The Michigan Court of Appeals in Fisher v. Fisher, 2008, held that incarceration or involuntary confinement does not automatically extinguish support obligations, but courts must examine whether the parent has diligently sought to satisfy the obligation given their circumstances. Additionally, the federal Bradley Amendment, 42 U.S.C. Section 666(9), prohibits retroactive modification of child support arrears, meaning Bennett's $16,103 debt continues growing regardless of his rehabilitation status. The judge faces the tension between these legal principles. Bennett cannot earn income while locked in residential treatment, yet the law does not forgive accumulating arrears. The prosecutor emphasized Bennett has no physical disability preventing work, distinguishing his situation from cases where courts have found true inability to pay. However, the counselor's testimony that Bennett cannot leave campus or obtain employment creates a factual basis for the court's temporary forbearance. While the judge is warning that, as soon as you're out, Your mine reflects the legal reality that voluntary unemployment or underemployment after rehabilitation would trigger contempt sanctions under Michigan's civil contempt framework. This exchange illustrates how child support enforcement intersects with public health policy on addiction treatment. Courts must avoid creating perverse incentives where parents avoid rehabilitation to maintain income while protecting children's financial needs. The judge's decision to monitor rather than immediately sanction Bennett preserves both the child's future support rights and the parent's recovery pathway, demonstrating how family courts balance rigid statutory obligations against individualized, equitable considerations.
In more than tried to help him and give him the chance. And when we were in front of Mr. Legal last month, I made it known that he is able to pay on his fines in Jackson since October quite a bit. And regardless if he doesn't have a job or not, someone's paying those fees. Since our last court date, I did look it up last night, he has had a suspension on that, so he doesn't have to pay on that or address that until March. So it's been pushed out until March. He's supposed to pay on it, but I'm sure that he went to them or something's happened because he doesn't have to pay right now. But since he has been in rehab, he has paid quite a bit to those fines, and I have seen nothing. And I understand that he can't work, and I understand that addiction is a process, but it's also frustrating.
I can certainly understand your frustration. Mr. Bennett, as to the payment of fines and costs, but not child support, what happened there?
Like I said, I'm going to rehab. I'm not working now. I'm not working at all.
You already told me that, but she says that you managed to pay some money towards fines and costs, but you haven't paid him a dime towards child support.
No, I didn't.
That was what my question was.
I didn't. She's not correct. I didn't pay fines and costs. I don't know where they got paid at, but I didn't pay it.
I can share my screen, and of course I can't see who paid them, but I could share my screen with you and look it up on his case in Jackson County.
All right, so Mr. Bennett, so who's paying money on your behalf to Jackson County on your fines and costs?
I have no idea. I have no idea, sir. I didn't even know someone was paying.
I find that really hard to believe.
Yeah.
Money doesn't just magically appear in a court's bank account.
That's the truth.
The custodial parent revealed that someone has been making payments on Bennett's unrelated criminal fines in Jackson County since his rehabilitation began, while Bennett denied any knowledge of these payments, creating apparent inconsistency with his claim of total financial incapacity. Michigan's civil contempt statute, MCL 600.1715, permits courts to imprison obligors for willful failure to pay child support, with Purcell v. Purcell 2010 establishing that contempt requires proof the defendant had the present ability to comply with the court order. The present ability standard distinguishes between true inability to pay and willful non-payment, with courts examining whether the obligor diligently sought to satisfy the obligation through available means under Michigan v. Sires, 2015. Courts may consider whether third-party assistance could be directed toward support obligations rather than other debts, particularly when the obligor benefits from such payments. The judge's skepticism about magically appearing money reflects this legal scrutiny of whether Bennett's financial incapacity is genuine or selective. The mysterious payment of Bennett's criminal fines while child support remains unpaid undermines his claim of total financial helplessness. If third parties are willing to pay his legal obligations, the court may infer that similar assistance could be directed toward child support, or that Bennett has failed to prioritize his children's needs. The judge's pointed questioning tests whether Bennett's rehabilitation facility confinement constitutes true inability to pay, potentially excusing contempt, or merely inconvenience, which would not. The discrepancy between paid fines and unpaid support suggests either third-party favoritism toward Bennett's interests over his child's, or Bennett's own failure to direct available resources appropriately, either of which weighs against finding his non-payment truly involuntary. This factual dispute highlights how courts evaluate credibility in contempt proceedings. Obligors cannot selectively pay some obligations while ignoring child support and claim complete poverty. The judge's evident disbelief signals that Bennett's rehabilitation status alone may not shield him from future contempt if the court finds he had access to resources he failed to apply toward support. For viewers, this demonstrates that inability to pay is a fact-specific determination requiring examination of all financial circumstances, not merely the obligor's employment status.
And I also kept pushing it out and letting Mr. Legal push it out and give him the benefit of the doubt, you know, and Mr. Legal knew about this and said, well, you know, if you can make a payment, then we don't have to put out a warrant. And since then, he's reached out to 2 other family members trying to get them to take Adam without me knowing to see Tim. It's very frustrating. It's tolling.
If Mr. Bennett, and it does appear that Mr. Bennett is in a rehab facility, inpatient, and I have no reason to believe that he's not, the court is not able to take sanctions against him for failing to pay his child support. Once he leaves that facility, that is no longer true. So Mr. Bennett, if other bills that you have are being paid, whether that's through the gifts of somebody else or not, and you are not making any payments towards child support, you will be subject to the court's contempt power upon your release from the facility that you're in. That means as soon as you're out, you're mine. You understand what I'm saying to you? Don't play games with me. If you've got money available to make your child support payments, make your child support payments. Even if it's not a full payment, any payment would be something rather than nothing. And if you've paid nothing since 2024, you are highly likely to go directly from your rehab to jail. Do you understand what I'm saying to you? Any way that there's a program in the rehab facility that you can gain some assistance through child support and you can begin to make some payments, I would say that that is highly in your best interest to do so. Do not take the court giving you grace now for the court being unwilling to put you in jail. I have no such, you understand?
Yeah, I'm aware of that. I'm aware of that.
Good. So we're going to adjourn for 30 days. We'll find out whether or not you continue to be in rehab, and we'll keep monitoring your position at the facility in Flint. As soon as you're out, I need to see payments in full starting. We'll adjourn for 30 days. Thank you very much for being here, Ms. Schultz, and giving me that information. I'll see you in 30 days, Mr. Bennett. Make sure that you're making some progress. That's all for today.
The judge explicitly deferred contempt sanctions based on verified inpatient rehabilitation status, while delivering a clear warning that any post-release failure to pay will trigger immediate enforcement and set a 30-day monitoring hearing to track Bennett's continued confinement and eventual transition. This judicial approach reflects the conditional contempt framework recognized in Mulligan v. Mulligan, 2012, where Michigan courts may postpone contempt sanctions when the obligor demonstrates concrete steps toward rehabilitation that will restore earning capacity, provided the court retains jurisdiction to enforce compliance prospectively. Under Michigan Court Rule 2.615, courts may issue show cause orders with delayed enforcement mechanisms, and MCL 552.603 permits income withholding to commence immediately upon employment. The judge's warning that as soon as you're out, you're mine operationalizes the principle from Heinemann v. Heinemann, 2009, that post-rehabilitation employment creates a rebuttable presumption of ability to pay, shifting the burden to the obligor to demonstrate continued incapacity or face coercive sanctions, including imprisonment, under MCL 600-1715. The judge's ruling creates a conditional safe harbor. Bennett's current confinement protects him from contempt, but this protection expires upon discharge. The 30-day review mechanism ensures the court can verify continued rehabilitation rather than relying on self-reported status, while the explicit warning eliminates any claim of surprise when enforcement commences. By requiring payments in full starting upon release, the judge establishes a clear standard for compliance that will support future contempt findings if unmet. The reference to other bills that you have are being paid preserves the court's ability to investigate the fine payment discrepancy if Bennett's post-release financial disclosures reveal available resources. This conditional approach balances multiple interests: the child's need for eventual support, the parent's recovery from addiction, and judicial economy in avoiding premature contempt that would be uncollectible. For legal observers, it demonstrates how courts use procedural tools, continuances, monitoring hearings, and explicit warnings to manage complex enforcement scenarios where immediate sanctions would be counterproductive, but permanent forbearance would undermine the support system's integrity. The case illustrates that rehabilitation can pause enforcement but never extinguishes the underlying obligation. The court adjourned the show cause hearing for 30 days with no immediate contempt sanctions imposed. Bennett remains subject to continued monitoring of his rehabilitation status at Flynn Odyssey House, with the explicit understanding that enforcement, including potential imprisonment, will commence immediately upon his discharge if he fails to establish payment arrangements. The $16,103 arrearage continues accruing at $703 monthly, and the court-reserved ruling on the discrepancy regarding third-party payments toward Bennett's unrelated criminal fines. This case illuminates the fundamental tension in child support law between the child's absolute right to financial support and equitable considerations of parental incapacity. The legal system treats child support as a non-dischargeable obligation that survives bankruptcy, incarceration, and even death of the obliger in some circumstances. Yet courts retain discretion to shape enforcement timing around genuine rehabilitation efforts. The critical educational takeaway is that inability to pay is never a permanent defense. It is a temporary status that courts scrutinize carefully, requiring obligers to demonstrate diligent efforts to restore earning capacity. Parents facing similar circumstances should proactively seek prospective order modifications under MCL 552.517 rather than allowing arrears to accumulate, as the Bradley Amendment's prohibition on retroactive modification means that even successful modification petitions leave pre-filing debts intact. For custodial parents, this case demonstrates the importance of documenting all financial inconsistencies and maintaining pressure on enforcement systems, while recognizing that courts may legitimately defer immediate collection when rehabilitation offers the best long-term prospect of sustained support. If you are struggling with child support obligations due to job loss, disability, or rehabilitation, do not wait for contempt proceedings. File a motion to modify your support order immediately, as delays only increase unmodifiable arrears. If you are a custodial parent owed support, contact your local Michigan Friend of the Court office to request income withholding and enforcement services at no cost. For viewers interested in learning more about how courts balance enforcement with rehabilitation, subscribe for our upcoming analysis of Michigan v. Sears and the present ability to pay standard in contempt cases.